Good afternoon, everyone. My name is Kristen Salas. I am one of the mentor attorneys here at the Dallas Volunteer Attorney Program, or DVAP, as we affectionately call ourselves. For those of you that are not familiar with DVAP, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association, and our primary mission is to match low-income Dallas residents with private attorneys that will work their civil case from start to finish. We get a wide variety of cases that come through the door, but one case that we seem to get more and more of, especially after COVID, is folks that need help with probates. And a good chunk of folks, sadly, their loved one did not have a will. So, like Jack says, crap, what on earth are we going to do here? So, we are blessed to have Jack Wilburn here to tell us what to do. Jack received his bachelor's of education from McMurry University and his JD from the University of Houston. He is a sole practitioner in Carrollton, specializing in probate, guardianships, and estate planning. He is a past chair of the Dallas County Probate Section, and he has just been a wealth of knowledge and one of the people I go to when I say, crap, I don't know what to do with this case. So if you do have questions, please put them in the Q&A at the bottom, and if we have time, Jack will get to them at the end. So without further ado, I will turn it over to Jack.
Thank you, Kristen. And a little behind the scenes, sharing my screen, I can't see the Q&A or any questions, so just chime in if you see a question that comes up that I need to stop and answer. But welcome, everybody. I am Jack. I don't do anything all day but probate and guardianship. I practice mainly in Dallas, Denton, and Collin counties. So if you are outside of those counties, forgive me if what I say doesn't particularly apply to where you are, but this is mostly general information. But I've given this presentation a number of times, and the biggest problem is always, what are we going to call it this year? And so now here we are with crap. There's no will, and that statement has come out of my mouth more than I can count. And so, but it's not the end of the world. As I tell people, when I'm just chit-chatting with civilians, they ask about a will, and I say, I'm less concerned about somebody dying without a will than I am with them losing capacity without powers of attorney. I've got a whole lot more tools at my disposal if somebody dies without a will than if they lose capacity without powers of attorney. But if you have this come up and a client comes in and doesn't have a will, we've got answers for you. So if you've seen me talk, you know I always like to start with a joke or something funny. As the Bible says, the meek will inherit the earth. But as any smart person says, well, we may need a lawyer anyway, because it's never that simple. So how often does it happen that someone dies without a will? Reports, information that I have been able to uncover says about 70% of people die without a will. And those numbers are, they seem to be consistent. I've been giving this speech for a number of years now, and that percentage doesn't ever seem to change. So I guess 70% of people are always going to die without a will. And the question is, so now what? And to me, the most important conversation you have is the conversation you have with your client and finding out if they do or do not have a will. And the main thing I like to start talking about is what kind of assets are we talking about and how are they held? Because that determines a lot of how you're going to do what you're going to do. it is possible that all the assets that someone had are either non-probate assets or, and because of that, there's no need to go to probate. I say this several times a week, just because someone died, even with a will, doesn't mean we have to probate the will. Just because somebody died doesn't mean we have to go to court. Let's look at what they owned. Let's look at how they owned it. And there's a possibility they don't even need a lawyer. And let me tell you, when you tell a client they don't need you, you've got a great referral source, because they're going to tell all their friends they found a lawyer that sent them away without them having to pay money. As you already know, trust assets are non-probate assets. So if someone created a trust, then those are not going to be subject to probate, and they're just going to pass via the terms of the trust. Bank accounts. So a lot of bank accounts are non-probate. If they're joint tenants with right of survivorship, and you're going to see this a lot in when you're talking to the surviving spouse, there's a high likelihood that the bank account is held joint tenants with right of survivorship, unless it's not, because the banker didn't have them initial the right box when they opened the account. Accounts can have payable on death provisions, or they can have beneficiary designations. So just because somebody died with a bank account doesn't mean it necessarily is going to be a probate asset. Retirement accounts or IRAs, those are generally going to have beneficiary designations. Or I learned this the hard way one time. The terms of the IRA contract or the written agreement will say who gets it. I walked away from a hearing with a lot of egg on my face one time because I was thinking of the laws of intestacy and learned that no, just because a retirement account didn't have beneficiaries listed, there was a provision inside the contract that said who got it. And I learned it, like most things, the hard way. Unfortunately, it was in front of a judge. So I'm telling you so you don't embarrass yourself like I did. And vehicles. A lot of times I'm talking to people and, we get down, they're worried about the cars. And there are two ways to deal with a car outside of probate without appointing an administrator. The DMV has an affidavit of heirship that you can fill out and give to them. And there is a place on a title. And if you can get to somebody before they die, they can do a transfer on death on the front of the title if they have the title in their possession. You might be asking yourself, well, gee, Jack, if somebody has a trust and has been told to do an transfer on death on their vehicle title, they probably have gotten good advice and already have a will. True, but just be aware of these things. Sometimes you can talk to a client long enough and figure out they don't need you, that you've transferred all the assets are transferred via non-probate means, and you don't need to go to court. But if that doesn't work, what tools are in your toolbox? And what techniques do we have for handling intestacy? Well, you can do a judicial determination of heirship under Chapter 202 of the Texas Estates Code. You can pair that, if you need to, with a court-created independent administration under 401 of the Texas Estates Code. Those are generally done as a combination. I have learned that some courts will not let you do those in one pleading. You have to file two separate pleadings, but you can just have one hearing and you end up with two separate orders. And some courts will just let you do it in one pleading and one order. So I learned a long time ago from a good lawyer named Carol Dabner that every court is its own kingdom. and each one of them can has their own way of doing things, and it behooves you to know which court you're in and how they like things done. And so just be aware of that. You have a dependent administration at your disposal under 306. You have the affidavit of heirship under 201. You have a small estate affidavit under 205. And some of these things aren't used a whole lot, but you can do what's called a determination of heirship and order of no administration. You can file an application for family allowance in order of no administration. You can do an administration of community property. And you can even file a motion to have access to an intestate bank account under 153. So let's talk about the determination of heirship. So this is a judicial determination of the heirs of an estate. The judge will literally sign an order that determines who the heirs of a decedent are. This always requires the appointment of an attorney ad litem to represent the unknown heirs. I suspect a lot of people listening to me right now are on the ad litem list and serve as an ad litem in heirships. If you aren't on that list, you should it's a good idea to be on that list. It's a great service to the court. Just be aware that each county has their own way of dealing with attorney ad litem fees. Some counties require that you deposit funds up to $600 for payment of attorney ad litem fees before they'll appoint the ad litem. So if you're sitting at your desk thinking, why has this court not appointed an ad litem yet? Well, make sure that they're not waiting on you to give money to the registry of the court so they can appoint one. And some counties don't require that at all. So again, just know which county you're in, know which court you're in, know what that court requires. But no matter what, and I tell clients this when we're talking about it, especially when they ask how much this is going to cost. Well, first of all, there's going to be 2 lawyers, and we're going to have to pay both of them. So just be aware of that. Once you get to a hearing, you are required to have the testimony of 2 disinterested witnesses. And we'll talk a little bit more about that here in a minute, but you can't get by with one. You need 2 disinterested witnesses. It requires a proof of citation on all of the alleged heirs, or you have to have each of the heirs sign a waiver of that citation. And some of you may have lived this, trying to explain to someone when you're asking them to sign a waiver of citation that all they're doing is waiving their right to receive a citation. They're not waiving rights to anything else. Can be a little complicated. So you decide whether it's easier to just have the citation issued or get a waiver. In connection, a lot of times, if you've determined that there are assets that you can only get your hands on with letters, and there's no will, you're gonna have to determine heirs, and you're gonna have to have someone appointed, either an independent administrator or a dependent administrator. Now, in order to get an independent administrator, you're gonna have to get an agreement of all of the heirs. And sometimes that's easier said than done. Sometimes your client is the sole heir. Sometimes your client doesn't know who the heirs are. And sometimes your client already knows that some of those heirs are never going to agree, no matter how nicely you ask. So have that conversation on the front end. It'll save you some trouble on the back end. And the way you get the agreement of all of the heirs is a document I call a designation, consent, and waiver. And that involves 3 different things. It involves the heir designating the specific individual to serve as the independent administrator. It has them consenting to their appointment, and it waives citation as well. It also you can have them waive service of amendments of the of any future applications for determination of heirship. We'll talk about that waiver a little bit more here in a minute. Most courts that I practice in require that you do the independent administration. They will not appoint an independent administrator unless they determine the heirs. So, generally speaking, if you only file an application for independent administration without a will, they're going to make you do the determination of heirship as well. One good thing about the independent administration is the heirs can waive the requirement of a bond, which can save some money. I am told that most of the courts that I practice in will not create an independent administration if there is a minor heir. I can tell you that that is the case in Dallas County, and it is most likely the case in Denton County. Other counties, your mileage may vary. So, you know, if you don't know, it doesn't hurt to ask. They can't say no if you don't ask. But in Dallas, you're just wasting your time. Now, the one thing that you should be aware of, and more importantly, your client should be aware of, if you're doing an independent administration, an independent administrator serves without court supervision. They are just out there with letters and a death certificate and not really answering to the court. They're not asking for court permission to do things. And generally, they're serving without a bond. So just be aware. There's upsides to this, but there's also downsides. So make sure that your client is comfortable with the risks involved. It is the most efficient and the least expensive way to do this, but it is also it can be risky. Let me see. I have a couple of questions here. Is there a current list of which courts require which procedures, things like that? Not that I'm aware of. I know that the Dallas Bar Association puts out, the probate section puts out a probate manual that has a lot of this in the back, but it only applies to Dallas. And I haven't seen it in a couple of years. When I was in charge of doing it, we used to try to ask Colin and Denton and Tarrant the same kind of questions and see if we could at least cover the 4 big counties around here. But I'm not aware that there is a broad, general list of who does what. Can the designation, consent, and waiver document or waiver of citation be executed via unsworn declaration? It depends on the judge. I've had some judges accept that. I've had some judges not accept that. And so that goes back to just know your court. And if you don't know, ask. So those are good questions. Keep them coming as they come up. All right, let's see here. Well, let's see. I can't see what that says. Like I was saying, this is the most cost-effective way to do this, but it's also the least protected way. Okay. Here's a couple of things that I would just call common mistakes or practical tips that I reached out to a couple of judges and asked them, hey, what are the biggest problems you're seeing with your heirships? And what are your, I use the word pet peeve, that's my word, not theirs. But what are you seeing that's causing problems? And so let's just go through these. So maybe this will save you some headaches. Make sure you're asking for what you want. Make sure you're asking for an independent administration and a declaration of heirship in your prayer. And make sure you're also asking if you want them to serve without bond and you're asking for authority to sell real property for your independent administrator, put that in your prayer. Ink is cheap and words are cheap. So more words are better than less words sometimes. when you are doing your designation and consents, make sure that you've got the proper name of the proposed administrator. Make sure that matches the name in your application. I'm a prime example of that. 99% of the world knows me as Jack Wilburn. Apparently, my parents hated me, so they named me David Jackson Wilburn II. And let me tell you, that causes more trouble than I can shake a stick at. So just make sure you're being careful with the name, and it matches. And make sure if you've got a piece of real property that you want your independent administrator to be able to sell, put that your heirs are consenting to that power in your designation, and then list that power in your application, and then make sure it shows up in your order. That's what your title company's looking for. You don't want to have to come back and file an application to sell property when you could have avoided that on the front end. When you're doing your order or your judgment declaring heirship, regardless of what you think the decedent owned, spell out all the shares for separate personal property, separate real property, and community property. The court is not going to make a determination as to what is community and separate property in an heirship application. And believe me, I've been there, done that, tried to tell the court, oh, you know, it's all community property. And they're like, nah, we need all of it listed. And so just go overboard with that. Just list everything, list out all of the percentages for each heir of the specific kinds of property. Save yourself some embarrassment and make sure that all of your citations have been done. And a lot of courts won't even let you set a hearing until this is done. They're making sure that you've done all your homework before they'll even set a hearing. But you've got to do posted citation. You've got to do citation by publication. You've got to do that OCA. So just make sure all of that is done. Let's see, we got a question here. Doesn't the independent administration authorize sale of real property? Not if you don't specifically say it. That's what I'm saying. If your independent administrator doesn't have that authority in writing from a judge, the title company's not going to let you do it. So just be aware of that. So make sure all your citations are done. Make sure you've served the heirs. Make sure you've published everywhere you need to publish. Make sure you've done everything that you need to do. And let's see here. Include language in your consents that if you have the parties waive, this is what I was mentioning earlier. If you can include amended pleadings in your waiver, it just saves you a step of having to issue citation if you have to amend your determination of heirship. All right, let's see here. OCA, I think, stands for Office of Court Administration. It's just a layer. It is a, I believe it's a state office that oversees the courts, and they have to list or publish the determination of heirship as well. In most of the counties I practice in, that's just automatically done, so I don't pay a whole lot of attention to it. But you want to make sure that it did get done, because sometimes things slip through the cracks. And while this just occurred to me, you are probably aware that the Dallas County courts are moving as we speak and will be up and running later this week. Everybody down in that court is going to need a lot of grace. There's been a lot going on down there. So if your citation slipped through the crack, just be gracious, because there's a lot of moving parts down there. And I wouldn't be surprised if some things just get dropped, not because anybody wants them to. It's just that's the nature of the business, and that's a huge undertaking, moving those courts. So just take 100 pounds of grace with you when you're dealing with Dallas County right now. Let's see here. What else do I have? Make sure that your uh, make sure that your disinterested witnesses actually can testify to the history of the decedent's heirs. If you've got a 70-year-old guy that died and you're bringing in a neighbor that knew him for 2 years, that's not going to get you there. Or technically speaking, a spouse is a disinterested witness. Don't bring the spouse in and have the spouse testify that the applicant is the sole heir. Most judges aren't going to let you slide on that. And this is a good tip that one of the judges mentioned. You can bring as many witnesses as you want. You might have a witness that covers the first half of life and another witness that covers the middle half of life. That'll get you there. Or if you can't get that done, you may have to hire a forensic genealogist. You may just have to have somebody come in that is an expert that has done the research and can testify as an expert witness and save you that trouble. Let's see, more Q&A. Will we be able to get a copy of the presentation documents? I believe this all gets sent to anybody who is a registrant. I think that's right. If you don't get it, I'm jack@jackwilburn.com. Shoot me an email and I'll send you a copy. But I think everybody who signed up ends up getting a copy of this. So let's see. Most courts use Zoom now, and this has been revolutionary. If you're from the dark ages like I am, used to, if your best witness was from Chicago, you had to fly him in for a hearing. Now most courts will let you have a Zoom hearing, and you can find the best witness available wherever they are. And you don't have to do deposition on written questions. You don't have to fly people in. So avail yourself of that and make the court's job easier by giving them the best witness testimony that you can give them. So they're not sitting there hemming and hawing about, man, I just don't know if this witness knows what they're talking about. Bring somebody in that knows what they're talking about, and your hearing will go better. Let's see what else. This is some more practical tips from some judges I ask. Make sure that your affidavits are done. Make sure that if you've got a dead dude and your heir is a child, make sure that you've got good paternal inheritance facts. Make sure that you're always, essentially the way I like to think about it is over-explain yourself. Don't just say, hey, Billy died and his wife Susie was dead before he died, and he's got these 3 kids and here they are. It really helps. Hey, Billy married Sally in 1957 and they remained married to each other until 1997 when she died. And during their marriage, these 3 children were born, and here are their names and their dates of birth. That is a better way to say that. So don't be chintzy with the words, just lay it out. Again, make sure you're giving proper service on the heirs. Everybody that you list in an application is entitled to citation or they need to sign a waiver. And don't ask for co-administrators. The court will not appoint co-independent administrators. That's left for executors to do in wills. Fun little party fact, if you want to bore your friends, the difference between an administrator and an executor is named in a will, and an administrator is appointed by a court. So if you're doing a court-created independent, you will never call them an executor. And if you've got a will and they're named in the will, you'll never call them an administrator. So fun little fact to bore your friends with. Let's see. Again, make sure you're asking for power of sale in the application and put it in your consents and your order. This is my favorite. I've been got with this before, and it's a hard lesson to learn, but when you have someone who dies without a will and you're going into heirship, sometimes other people are dead. And you end up doing what I've heard referred to as nested heirships. And at some point, you just can't keep doing that. So make sure that you are proving and serving the heirs of a post-deceased heir, including a personal representative. Or if they don't have that, you may have to do citation by publication. So just be aware of all these things, and it never hurts to reach out to your ad litem. They may have some experience with this and be able to help you with that. Let's see. I think we have some more questions here. Let's see. Why are co-administrators not acceptable? My understanding is they're not allowed under the code. There's not a code provision that allows for that, so judges don't do it. So, let's see. Another comment or a little practical tip. And I touched on this earlier. I've gone into court before and I've got a surviving spouse with minor children, but they're children of the marriage. So the surviving spouse is entitled to all the community property. And I believe that there's only community property. And I will say to the court, but judge, there's no separate property. And everything's going to the surviving spouse. And so she should be able to be an independent. And the court will say, nope, I'm not determining whether or not what the nature of any property is. You've got to list it all out, and you need to make sure that you're serving everybody, either that is children or parents of the decedent if there were no children. Let's see here. Don't try to sneak a common law marriage into a determination of heirship. You have to do that as a deck action. And there's the site, Civil Practice and Remedies Code, Chapter 37. I've tried that trick as well and had my hand slapped. So if you're going to do a common law marriage, you have to do it as a declaratory judgment. You can't just slip it into a determination of heirship. So that was all about independent administrations. If you can't get an independent because you've got minor heirs or the siblings can't stand each other, the court will allow you to appoint an administrator, but they're going to be dependent. So it doesn't require the agreement of heirs. Again, the court most of the time requires a simultaneous determination of heirship, so everybody knows what's going on. In limited circumstances, I've been able to just do a dependent administration without heirship, but it always bites me because I have to do the heirship before I can close it anyway. So just knock it all out at once. There's a bond required for the assets of the estate that are liquid. You don't have to bond for real property, but you do have to bond for everything else. A dependent administrator is required to file an annual account. That's not required by an independent administration. You're required to file a final account. That's also not required of an independent administrator. Those two, the bond and the accountings, those necessarily increase cost. So if everybody will agree and it makes sense to do, it's more cost effective to do an independent. But if everybody doesn't trust each other and it's a little hinky, just go dependent. You can use one of the heirs, or a lot of times I see the court appoint disinterested third parties, lawyers, to serve as dependent administrators. There's a cost associated with that, but at least you know it's being done properly. And obviously this provides the most protection for the heirs. So, but again, it can be expensive. So now this one, depending on who you ask, this is controversial. I have a few lawyers that just hate affidavits of heirship, and I have some lawyers that love affidavits of heirship. So first of all, Jack, what's an affidavit of heirship? It's not a court proceeding. It is just an affidavit spelling out a decedent's heirs, and it's filed into the deed records. But you spell out who the heirs are. And again, this goes back to it's better to over-explain than under-explain. You know, Billy was born on this date and he died on this date in this county, and he was married this number of times during his lifetime. He was married to Sally on this date, and that marriage ended in divorce on this date. He then married Susie on this date, and he remained married to her until his passing. During Billy's lifetimes, so-and-so children were born. Here are their names. Here are their dates of birth. And you just spell everything out. And this is signed by two disinterested witnesses. And you just file it in the deed records. Now, where it gets, I hate to use the word controversial, but where people differ on this is how long it has to be on file before anybody will rely on it. And let me tell you when I most likely would use an affidavit of heirship. I've got a surviving spouse. She's entitled to all the community property because the children are children of the marriage, and the house that they're living in, which is the only asset that we're worried about, is a community property asset. So it's all going to her. So rather than do a determination of heirship and an independent administration, if she doesn't have plans to sell that house within a year or two, an affidavit of heirship will generally work. You just draft it, get it signed, file it, let it sit there until she's ready to do something. And most title companies that I deal with will accept an affidavit of heirship if the decedent's been dead for a year. I've had some that'll go as low as 6 months. I've had some that require at least a year. So, but under the code, the affidavit containing the statement, if it's been on record or been recorded for 5 years or more in the deed records of the county in which the property is located, that is basically prima facie evidence of its validity. So 5 years will get you there, less than 5 years, it's kind of a hit or miss. But an affidavit of heirship is a whole lot cheaper than a full-blown administration. So just something, again, we think of these as tools in a toolbox. That is a tool in your toolbox if the facts fit. Another tool in your toolbox that might fit if the facts are appropriate is a small estate affidavit. These are filed with the court. You can't have exempt assets that exceed $75,000. They also require two disinterested witnesses. It does not create an administration. Most importantly, these can be done pro se. You do not have to have a lawyer to fill out a small estate affidavit. Some of my worst cases are me trying to do small estate affidavits, and it just becomes, you end up spending more time and money than it's worth when the client ends up being upset because it was so expensive. And I'm pretty much to the point, I don't do them. I send them the link to the small estate affidavit packet in Dallas County, and there's the link that will be on the presentation documents when you get it. There's a whole little packet. There was a time years ago when all small estate affidavits ran through Judge Monroe in Dallas County. My understanding now is that each court handles their own, depending on which court it landed in. Some courts will not approve a small estate affidavit if there's real estate involved. So here's a couple of links for you that'll get you pointed in the right direction. I just send these links to people that call in and say, here, it's pretty self-explanatory. Good luck. You're better off doing it yourself than paying me to do it. So that's that. Now, we've talked about determination of heirship and independent administration and determination of heirship and dependent administration. If you really want to gild the lily and there's no necessity for administration, but for whatever reason, you don't want to do an affidavit of heirship, you don't think they're worth the paper they're written on, and you want a determination of heirship, you can get an order determining the heirs, but finding that there's no necessity for administration. It's completely discretionary. It merely formalizes that a determination of heirship only can accomplish on its own, but it gives you a little extra protection that says, and there's no necessity for administration. Sorry, I got ahead of myself there. Let me see. Anybody's got any questions? Let's see here. What do you think about slipping a common law marriage into a small estate affidavit? Good question. You know, my philosophy of life is if you don't ask, they can't say no, and it might be worth trying. Is the parallel, let's see, is there a parallel section of the estates code that specifically says common law marriage must be determined exclusively by dec action? I do not know the answer to that. All I know is that the courts I practice in require a dec action to do a common law marriage. So you're welcome to argue that out with them if you want. Let's see. Let me see if I can get myself. Okay. And again, just remember the spirit of this presentation is, dadgummit, that person died without a will. What can I do to help this person that doesn't have a will? And I'm trying to avoid full-blown letters if I can. Remember, our very first conversation is, what assets do you have? Oh, you don't need to go to court at all. Everything's non-probate. You can all kind of a quasi halfway fix for that may be an application for family allowance in order of no administration under 451. It provides for a procedure for a court to dispense with administration if the decedent is survived by a spouse, minor child, or adult incapacitated child. So if you've got somebody dead without a spouse or a kid, this ain't gonna work because it says, and the value of the estate does not exceed the family allowance. So if the facts fit, this is a great tool. If they don't fit, don't bother because you're not going to get there and you're going to waste time and money. So just tuck that away. This is that weird little wrench that's in the back of your toolbox that you don't use very often, but it's good that it's there when you need it. I don't know that I've done one of these in the past 4 or 5 years, but it's good to know that it's there. There's also a provision for administration of community property. Section 453.003 and 004 permit the surviving spouse to administer the community property in both testate and intestate situations, provided no personal representative has yet been appointed. It's often called an unqualified community administration. So let me say all that carefully. You can do it if there's a will or no will, but you can't do it if you've already appointed an administrator or an executor. So make sure you know this tool is available to you before you get too far down the road. And you could have avoided a full-blown administration by using this tool. All right, let's see. We got a question here. If an affidavit of heirship is an affidavit of heirship a reasonable choice if the decedent had small value mineral interests, royalties? I don't see why not. as long as you file that affidavit of heirship in each county where the mineral interests lie. Because again, it's just a document that says, hey, so and so's dead and here's who their heirs are. Um, I will tell you from personal experience, and a lot of y'all know a whole lot more about this than I do. Um, you also have to reach out and send letters to the production company and make sure they reissue the uh, the order of payment, so the money goes to the right person, right? Because all we're really, at the end of the day, everything we're doing is trying to get money from dead people to live people. So uh, don't forget that that's the ultimate goal. So you can file things, but if you don't take the next step to let the people with the money know that it's filed, it's not going to really be effective. Let's see. I'm involved in a jury trial as attorney ad litem next week, where a common law marriage is the only triable issue. I have told both attorneys what you said about deck actions, and they don't agree with us. I don't know why judges allowing them to have a jury. So, oh, don't read this aloud. For future reference, put that at the front of the question. I don't know. I'm going to go back to every court's its own kingdom. I don't speak for judges. I don't speak for cases I'm not in. What I'm giving you is general information. If what I'm telling you contradicts anything you've heard from a judge, the judge is the boss. I'm just some idiot out here who agreed to give a talk during lunchtime. So, on the hierarchy of people you should listen to, judge, attorneys in your case that know more about your case, an attorney you've talked to specifically about the case, idiot Jack Wilburn who's just out here talking about general things. So I'm just a dude. So let's see here. This has come in handy a few times, and so just be aware that's there under 153. One of the questions I always have of someone, if I'm trying to decide if maybe a small estate affidavit will work or community administration will work, is, well, how much money's in that bank account? You can file, and they won't ever tell you, right? They're like, well, we're not telling you. You can file an application to get this information. And so just be aware that that's there. Oh, we're running out of time. All right. Who gets what? If someone dies without a will, the state of Texas has a will for them. The laws of intestacy dictate what heirs will receive and what specific types of property they will receive. That's under 201 of the Estates Code. Here's a link to a chart. If you Google Texas intestacy chart, you will more than likely find this. This one's out of Collin County, but they're all over. The first time I ever saw it was when I was clerking in Probate Court 1 in Houston. Judge Russell Austin had done one. So, but it's a really handy little cheat sheet that shows you under what circumstances who gets what. Were they married with kids? Were they single? Or were they widowed with kids? And those of us that do this every day, we think we know everything and we think we have everything committed to memory. But sometimes weird things happen, like somebody dies married but with no kids. That changes. Logic would tell you, oh, they were married, everything goes to the spouse. Oh, wait, they didn't have kids? Well, now that spouse is splitting the assets with mom and dad. And it depends on whether mom and dad, mom and dad, or siblings. So this is just a handy dandy little chart you can look at that'll help you. I refer to it often. And oh, by the way, the time to refer to this is when you're drafting your application, not 5 minutes before the hearing. Okay. Make sure that you know who is entitled to what when you're drafting your application. And sometimes you do the best you can. You talk to your clients. You trust that what they're telling you is the truth. I understand that, but just make sure you're taking efforts to understand the basics of who gets what. Let's see. I think we have another question. Let's see. What does the process timeline look like for asking court for permission to sell real property in a dependent administration in Dallas? You file an application to sell real property with an order to sell real property, and you post citation, and after it sits there for about 3 weeks, if there's no objection, they'll sign your order. That's generally how that works. Okay, let's see here. Okay, I just want to make you aware of this word and this concept called a moiety. And moieties come up when if someone dies, they are not married when they die, they don't have kids when they die, and their siblings or their parents are already dead or never existed. You're going to have to end up dividing the estate into two moieties. One moiety goes to the paternal side, and one moiety goes to the maternal side. So basically, you're looking for cousins on dad's side and cousins on mom's side. And essentially, you go up to the grandparents and then you go out until you find heirs. This is where you most likely need a forensic genealogist. This is complicated. It's really hard to prove up the steps it takes to figure this out are maybe beyond our capabilities as probate lawyers and maybe done better by someone who is a expert in that field. In my mind, it's better for my client to give $1,500 to a forensic genealogist than to pay me to do it, because it's going to get done right and it's going to be cheaper. But this is how you end up, if you've ever heard the phrase laughing heirs, these are where laughing heirs come from, because you end up with a third cousin twice removed who didn't even know the decedent ever existed, and they get a check for $100,000. But just be aware that it exists. And what you're looking for is, I've got a dead person. All right, are they married? No. Did they have kids? No. Did they have siblings? No. Are their parents still alive? No. And this is a term of art. The appropriate response to that is crap. I guess I got to call the forensic genealogist. So just be aware that that is an issue and that it exists. Let's see. That's the end of the presentation. Let me see. Are there any other questions that I can answer in our last couple of minutes? Kristen or Maricela, is there anything else we need to talk about in our last minute or so? Looks like you'll get a copy of the presentation emailed to you, and probably the thing you care most about, the little number, right?
Yes,
What do you call that? What's the course number?
the course number.
The
So
thing,
thank
the
you
only thing y'all
for
care about is the course number.
thank you, Jack, for the great presentation. I'm going to read out the course number and we'll also email it to you attendees following today's presentation. But that number is 174-264-737. Again, that is 174-264-737. And you can use that course number to file under your State Bar of Texas profile. And I don't believe we have any additional questions as far as I can see.
Oh,
Oh,
one thing I forgot to mention, I'm so sorry.
go ahead.
The Dallas Bar probate section presentation in February will be on Airship. It'll be Nathan Griffin and Kelvin Myers, who is a forensic genealogist. So everything I didn't cover, they will cover.
Awesome. Thanks, Jack, for plugging them in. We thank you all for attending the first CLE of the 2025 year. And if you have any questions following today's presentation, please feel free to reach out to me. And as I mentioned, a copy of today's presentation, the PowerPoint will be sent out as well as the MCLE course code. We thank you all for being here and hope everyone has a good rest of their days. Thanks, Jack.
Thank you all. Have a good day. Thank you, Maricela. Thank
Thanks,
you,
bye.
Kristen.